Did you buy a condo in the Riviera Maya and the developer hasn't delivered it? Here's what you can do legally in Mexico to recover your money. My name is Alberto Gutiérrez. I'm a real estate litigation attorney, and in this video, I will explain the real legal options you have when a developer breaches the contract. You bought a pre-construction property, signed the contract, and the delivery date arrived, but they didn't deliver the property. If you're in this situation, you're probably asking yourself, how can I recover my investment? Can I claim a compensation? And what legal options do I have? In short, you have three main paths: a formal demand letter, PROFECO, and litigation. I will explain each one, when it applies, and which ones make sense depending on your case. But before that, you need to understand a key point. In many pre-construction cases, legally the property does not exist yet. Why? Because the condominium regime has not been formally established yet, or the legal requirements for closing have not been met. This means they cannot legally transfer ownership on the property to you, even if you have already paid. That's why in cases of breach, the legal focus is usually on recover your money and, when applicable, claiming damages. Now, to act correctly, the first thing you need to do is organize all your documentation. This includes your contract, proof of payment, emails, and any communication with the developer. Why this is so important? Because the legal strategy depends directly on the contract you sign and the evidence you have. A contract with a penalty clause is not the same as one without them, and simple delay is not the same as a total breach of contract. Based on that information, the first thing to analyze is when was the property supposed to be delivered and when it's supposed to be titled. And pay attention to this because those are not always the same. In many developments, the unit is delivered physically first and later the title is transferred. This happens because the property is built first and only afterward the condominium regime is formally created, which legally allows individual units to be transferred. It's also essential to review how much you were supposed to pay under the contract and how much you actually paid. This is critical because in order to demand the termination or enforcement of a contract, you are generally expected to have complied with all your own obligations. However, there are important exceptions. Some people ask me, what happened if I stop making payments because I didn't see any progress? Well, when the developer breach is clear and imminent, suspending payments may be justified. This can allow you to demand performance even if you have completed all the payments. But be careful, please do not make that decision without legal advice because it can backfire to you. On the other hand, the contract also allows us to identify penalties in case of breach, and even though many developers don't include penalties for themselves, that doesn't mean you cannot claim any compensation. Applicable regulations in Mexico, particularly Mexico Federal Consumer Protection Laws and NOM 247-221, requires the penalty to be equal. This means that if the contract includes a penalty for the buyer under the principle of contract fairness, it can be also enforced against the developer. With all this information, now we can decide what steps to take to recover your money. If the project is still ongoing, sales continue, and communication with the developer is still open, a strategy that often works is to start with a formal demand letter. This is usually done by your lawyer, informing the developer that there is a breach, that we are aware of the legal consequences of that breach and we are prepared to take legal action against them. In that same document, we request a refund with the compensation under the law or the contract. In many cases, this opens the door for a settlement. What usually happens in the practice is that there is a refund with a partial compensation, additional benefits if the client decides to continue, or maybe they offer improvements on the unit. Now, it's important to be clear, this solution rarely involves a full compensation. However, they have a major advantage. They allow you to recover your investment faster and with less friction compared to litigation. That is why, in many cases, it's worth exploring before filing a lawsuit. There will be situations where this is not viable option, either because the developer refused to negotiate, gives evasive responses, or propose bad terms for the recovery of your money. For example, refunds over 2 or 3 years, payment conditioning on reselling the unit. In these cases, another option is go to the Mexican Consumer Protection Agency, PROFECO. But before that, you need to understand this clearly. PROFECO proceedings are conciliatory, not coercive. This means they cannot directly force the developer to refund your money. Knowing this, the question is it worth going to PROFECO? And the answer is yes. Filing a complaint has a strategic value. When a violation is established, for example, unregistered contracts or failure to deliver, the PROFECO can impose substantial fines. In practice, this creates enough pressure to make many developers want to settle and refund your money. Additionally, PROFECO can issue a technical opinion. This is important because that opinion can be later used in court and in certain cases support an expedite enforcement action, similar in an effect to a promissory note. This significantly reduces the complexity of litigation since the breach is no longer the main issue to prove. Now, there's a critical factor many people overlook: time. PROFECO complaints are subject to 1 year limitation period from the breach of the contract. After that, your right to file a complaint expires. That is why the most important thing is this: do not let the breach sit. As time passes, your legal options become more limited. The developer may lose solvency or even disappear, and it makes recover your money much more difficult. When everything else fails, the only real option is litigation. At this stage, a lawsuit will be filed detailing the developer's breach, either failure to deliver on time or failure to build what was promised. This claim will include refund all the amounts paid and the compensation. You will also present evidence to prove 3 key elements: the existence of a contractual relationship, the compliance of all your obligations, and the developer's breach of the contract. Of course, the developer will have the opportunity to defend themselves, and ultimately the court will issue a judgment. If the judgment is on your favor and the developer do not fulfill voluntarily, you can proceed with the enforcement, seizure of assets, foreclosure sale, or even freezing bank accounts. But you need to understand the reality of litigation. It is not fast and is not simple. And a favorable judgment do not always guarantee the recovery of your money. Why? Because the developer may be insolvent, may have hidden assets, or maybe already be facing multiple claims. Additionally, you will incur in legal costs and face potentially long process. That's why litigation should be seen for what it is: an effective tool, but a last resort. But if you really want to protect your investment, the most effective strategy is prevention. This video is part of a full series on pre-construction real estate in Mexico. If you're planning to buy, make sure you watch the complete playlist where I explain what to review before signing, hidden abusive clauses, and the risk involved in pre-construction property. And if you're already dealing with a breach, you can contact me directly to review your case and determine what is the best legal strategy.